And of course, it's always good to have the icebreaker spot, so here I am. It's a lawyer's cliche that hard cases make bad law. We could rephrase that in environmental jurisprudence to hard cases make all the law. And landscape does seem to provide many of those hard cases. One of the questions that's been posed by the King Salmon decision is about retrofitting. Do we need to rewrite objectives, policies and methods for plan changes that have been notified but were not operative as at the time the King Salmon decision was handed down? Now this question especially applies in the coastal environment, but King Salmon also applies by analogy to other national policy statements such as the NPS freshwater, the Toki case mentioned earlier. I'm pleased that I can leave to Dave Sargent the bigger picture questions about King Salmon. Man of War was specific to the coastal environment, and Man of War, like King Salmon, is above all a landscape case. The main question decided by the High Court is the impact of King Salmon on the mapping and identification of ONLs. The question, to the question, does King Salmon introduce a new threshold for identifying ONLs, or do we stick to the tried and tested Wakatipu and Wezi landscape factors? The short answer in this short presentation is no. King Salmon does not affect the process of identifying and mapping ONLs. Anyone know the next page? Oh yeah, going backwards. If someone can just find me page 2, that would be very kind of you. Basically, page 2 is a slide about King Salmon. There we go. Great. The starting point to understand Man of War is to revisit King Salmon, and again, you'll hear much more about this from Dave Sargent. Of course, everyone calls it King Salmon, but rightly it should be called the EDS decision. So we'll change that starting now. And it was, of course, a landscape and natural character case. The decision confirmed that Section 6 intangible effects that are protected under the Coastal Policy Statement can't be traded off. Under Policies 13 and 15 of the Coastal Policy Statement, adverse effects to ONLs and outstanding natural character areas must be avoided. So avoidance trumps the balanced judgment approach. The concept, as mentioned earlier by Raywin, of environmental bottom lines. And as noted, King Salmon has triggered a retrofitting process in regional and district planning instruments throughout New Zealand. Next slide, please. Great. Now this is a picture which I plagiarised off I think it was a Man of War site with a whole bunch of pictures of wine bottles, and there was, luckily for me, there was one of Waiheke itself, so I thought I'd better use that. Essentially, Man of War relates to Plan Change 8 to the Auckland Regional Policy Statement. It's a long-suffering and much-maligned beast, first notified in September 2006, still not operative. Plan Change 8 contained more than 90 separately identified areas of ONLs. 2 of those areas involved land owned by the Man of War station. And there was a major debate, as you might expect, between landscape experts. The principal focus was on the intermediate areas between the coastal and interior landscapes. In terms of sequencing, it was notified in September 2006, a decisions version issued 2010, and a number of interim Environment Court's decisions were released. Perhaps unfortunately for the Environment Court, it didn't get round to issuing a final decision before King Salmon, so it had to revisit some of the propositions involved. By this stage, though, Man of War was the last man standing, so to speak, as appellant, supported, though, by federated farmers. And most of the expert evidence was focused on where to draw the line at Waiheke Island and Ponui. There were 3 questions looked at by the Environment Court. The first question related to whether naturalness was predominant, whether it should be the sole or key focus when you're classifying ONLs, or is it just one of a range of factors? The second question, and this was sort of the King Salmon question, was whether the court needed to retrofit, to to have another look at the objectives and policies and a specific method in light of king salmon. And the third question was, do we need to go back and do all the mapping again as well because of king salmon? Now, of those three questions, to the first, the court said, yes, naturalness is an important factor, but it's not predominant. When you identify ONLs, there is a list, which we'll come to shortly, set up by the Environment Court, mainly out of South Island jurisprudence, the WESI factors. The second question, yes, thanks to king salmon, we do have to retrofit, go back and change some of our methods, OBS and poles. That exercise is still to be done, hasn't been done yet. But the third question, no, identification of ONLs is separate. It's a separate process from the policy framework that applies. The essential point that the Environment Court found was whether and to what extent land on the Man of War station is an ONL is a matter of fact. It's a matter of judgment and fact. And the planning consequences flow from the fact that land is ONL. They are not relevant to deciding in the first place if it is ONL or not. So leave it with the landscape experts, basically. Don't hand it over to the planners and lawyers. Just the next slide. Sorry, go one more slide, actually. Thank you. This is policy 15 out of the CPS, which is one of the two policies examined quite closely in king salmon. Now, it's sort of summarised, but it doesn't state all of the WESI factors. The Upper Clutha Tracts decision, there's been obviously a lot of jurisprudence over this over time, and we categorise and recategorise and categorise again how you approach landscape. But in Upper Clutha Tracts, three categories emerged. First were the biogeographical elements, patterns and processes. Second, associative or relationship contributions. And third, perceptual aspects. Now, obviously, outstanding landscapes are the exemplars in this category. One of the issues, and it was dealt with in Man of War, as you'll see, was that what is a landscape will involve the same criteria regardless of whether it's coastal or not coastal. And what makes a natural landscape outstanding, again, involves the same criteria regardless of whether it's coastal or not coastal. The third point, which received a lot of argument and emphasis, is that a landscape can be outstanding at a district, regional or national level. We're not just talking about the nationally important levels. So there are three simple questions you ask when you're trying to classify an ONL. The first, obviously, is it a landscape? The second, whether it's sufficiently natural to be a natural landscape. And the third, if natural, then is it outstanding? Outstanding is not defined by the RMA. Again, it's a factual inquiry. It's a real-world inquiry, as some of the case law describes it. And the High Court, in the Man of War decision, essentially agreed with the various phraseologies used by Environment Court decisions. It refers to unusual or exceptional. A handsome or picturesque landscape is not sufficient. If we can just go back one slide, please. Thank you. So in terms of the, that was the Environment Court. As you know, the next step in the line is High Court. Now, I've just kind of slightly simplified the questions for you, but the first question of law was, did the Environment Court fail to address the WESI factors? The issue wasn't really pursued in the High Court. The WESI factors were certainly considered, and the real question was whether we need to change the test for assessing the landscape in light of king salmon. The second question here, the High Court basically agreed with the Environment Court approach. The argument that was put up by Man of War as well, because king salmon requires that you avoid adverse effects in ONLs, we should apply a higher threshold test. It should be harder to qualify as ONL because the onus and imposition, the obligations on the landowner are higher. Now, the Environment Court noted two major concerns with approaching ONLs as being only nationally important ones. And quoting from the Environment Court, first, the task could become enormously complex, query impossible. Secondly, one might be forgiven for postulating that if pristine areas of New Zealand, like parts of Fiordland in the Southern Alps or certain high country lakes, were regarded as the benchmark, nothing else might ever qualify to be mapped as outstanding. The High Court agreed with that. Although Section 6B refers to protection of outstanding landscapes as a matter of national importance, this does not mean the landscape itself has to be outstanding on a national scale. So don't conflate the 2 points, basically. Because otherwise, in an area which is notorious for atomization and categorization and subcategorization, a new category would be required, the most outstanding of the outstanding. And the court also noted that it's not necessary to incorporate a national comparator or even a regional district one. The courts have not been asking, is this a nationally significant ONL? They have been asking simply, is this an outstanding natural landscape? Question 4 didn't receive a lot of airtime. In principle, it seems reasonable that you might introduce a coastal line, and certainly a number of regional councils have done that. But the argument here, the Environment Court took, again, a factual line and said, well, it's not appropriate at the RPS level to compartmentalise these landscapes, and there's no logical line to draw. So the court took a holistic approach. It said that there was a mosaic of landscape features which interacted, and when viewed from land or sea, it is difficult to identify distinctly separate landscapes. They had varying degrees of connection to the coast, so it was not appropriate to separate coastal and inland landscape areas. I think that's an issue that will receive more airtime in later case law around that point, where do you draw the line. Just moving to the next slide, 5. Thank you. So our next phase is Court of Appeal. Given the precedent implications, it will be no surprise to the audience that EDS is a party to the Man of War litigation. I'm pleased to say that so far EDS is playing defence, not offence. It was successful in Environment Court and High Court. Now, because it's now under appeal, for the purposes of today's seminar, we won't speculate on the outcome, what will happen at the third tier. But, of course, the High Court decision does apply in the interim, meaning that regional councils do have an obligation and district councils to identify, get on with the job of mapping, essentially. But my last point before the sand runs out of my hourglass was question 4, the fourth dimension. Now this issue was about the future use of rural land that is also ONL. The question posed by Man of War and supported by Federated Farmers is, well, are you sterilising rural land if you claim it's an ONL? What can you do with it? Can you alter it from pasture to viticulture? Can you construct rural barns and sheds? The short answer is that it depends on the context. Case law has confirmed a natural landscape does not have to be pristine or unmodified by natural intervention, and significant parts of this Man of War station were agreed to be by the landscape experts as ONL, which included areas modified by pastoral farming and viticulture. The simple point is if a landscape is ONL with rural activities, then continuing those activities cannot be an adverse effect on that landscape. If it's rural and classified as ONL, continuing to use it for rural purposes must be consistent. But any particular future use will need to be judged in the context of the landscape in question. It will essentially be a question of fact and merit. A pristine rural landscape will be less accommodating of built form than a non-pristine one. Last slide, please. Thank you. So I think I've hit my 15 minutes. So those are some of the implications, but I think essentially the points just covered with you now. Thank you.